Hi, and welcome back to Military Law Talks. So today I wanted to do a video about a week in review. So it's the last week of March 2025, and a lot has happened in the Trump administration, the litigation that has been ensuing that I've been following on this channel, and with the DOD. And so I just want to highlight a few of the cases that there has been movement on that I have been following on the channel. And so the first of that case is the Transgender Troop Ban. So I've done 2 videos so far on this. An initial video discussing the DOD policy and the change in policy. So if we remember back a little history, in case you haven't watched those videos, under the Obama administration, they conducted a study and then decided to allow transgender troops, those with gender dysphoria, to serve openly. However, that was right at the tail end of the Obama administration and didn't end up going into effect until the first year of the Trump administration. Then that was reassessed under Trump 1.0, and it was reversed. And so transgender troops could serve, and then they couldn't. And then under Biden, month 1, maybe even day 1 of the administration, that was reversed again. So reverted back to the Obama policy. So then transgender troops, or those with gender dysphoria, were allowed to serve pretty much openly and with no issues the last 3 years of the Biden administration. And then we have Trump 2.0 administration. So then that policy was again reversed. So back to banning military members with gender dysphoria, deciding that that's a disqualifying medical condition, and essentially they're going to be transitioned out of the military either voluntarily or involuntarily, and then not allowed to assess. So couldn't come into the military if you have a diagnosis of gender dysphoria. So there's been lawsuits, of course, filed immediately after that executive order was put in place, even before the DOD had implementing policies. And so I've been following the main case, and then I'm going to talk about another case as well. And so that main case is Talbott versus US. And that is a case that I've followed and I've done 2 videos on. And so the last video, I believe it was a week ago, there was an emergency hearing there. The DOD presented, hey, we have this new policy. And as I explained in my videos, their initial argument really wasn't coming from a medical perspective. And I said that that's what their winning argument should be. That's the argument they should put forward. The new policy that came out last Friday clarified and said this is about medical. You're essentially medically disqualified if you have a diagnosis of gender dysphoria, whether or not you live as a transgendered individual. That's not the issue. The issue is the diagnosis of gender dysphoria that makes the person disqualified for military service. And so the judge in that case entered a stay for a couple of days of her preliminary injunction. However, instead told the DOD essentially, like, don't take any action in regards to any of these soldiers and like discharging them. Then there was more hearings and more filings this last week. And then ultimately the judge denied the government's request for a stay, and essentially the preliminary injunction was in place, stopping the DOD from doing any sort of negative actions against anyone with gender dysphoria. So that was appealed. It was in the DC circuit. That was appealed to the DC circuit. And so there was a hearing on that this week, and we got a ruling from the DC circuit. So I'm going to share my screen. Okay, so here is the opinion that we got from the DC circuit. So it was, looks like issued, it's March 27th. So I believe that was Thursday of this week. And so again, it's Talbott versus United States. lots of plaintiffs, lots of defendants. And so this was making a decision on the appellants, which is the government, their emergency motion for an immediate stay pending appeals. And there was the order, like I talked about, that preliminary injunction that was issued in the district court. And so this order by the appellate court says that, yes, we are going to stay that preliminary injunction, which means it essentially pauses it. There's no preliminary injunction in place. And however, they make it clear that in this next sentence, if any action that would negatively impact the service members under the HECSEC policy in the new guidance before the court lifts the stay, the plaintiffs may file an objection and the courts will consider it. So essentially, while the preliminary injunction can't take effect, in practicality, it kind of has, because the court has said essentially to the parties, maintain status quo. DOD, do not do anything negative to the service members. Don't start processing them for elimination, because we want to be able to hear this lawsuit and resolve the lawsuit prior to any of that happening. And so while there is a stay on the preliminary injunction, in practical effect, it's as if there is no stay and the preliminary injunction is in place because the administration can't move forward on any action against these service members. And we'll see that this will continue, the appeal will continue, and we'll see what happens in this case. I'll be following that. But I did want to highlight a second case that it involves the Transgender Troop Ban. So let me find which one it is. Nope, that's the wrong one. Okay, so it's this one. It's Ireland versus Pete Hegseth. And this is in the District Court of New Jersey. And in this case, it's actually just two plaintiffs. So two plaintiffs, they are transgender airmen. They both serve in the Air Force, and they're suing the government, and they want the government to be stopped from initiating involuntary separation proceedings against them due to their transgender status. And so this was granted. And the court granted this 14-day temporary restraining order, essentially telling the Air Force you can't take any negative action towards these two airmen while this case is pending. And why I wanted to highlight this case is that the temporary restraining order only applies to the two plaintiffs in this case. And this is where I think the courts are on solid ground, in contrast to the Talbott case, where it was a nationwide injunction and applied to all plaintiffs, but all even future plaintiffs or any service member with gender dysphoria that could be potentially impacted by the policy. And so it included people who weren't even party to the lawsuit. And that's where I think the courts are definitely on shakier ground, issuing these nationwide injunctions. Now, I get the politics of it. I understand why they're doing it. But from a legal standpoint, it's definitely more solid legal ground to only apply the injunction to the parties of the lawsuit, right? Remember, in the Constitution, the judicial branch can hear cases and controversies. And so they can't issue what's called advisory opinions. So they can't issue something that's like, hey, we have this hypothetical situation, or we have this future case that might come up. Can you just give us what your opinion would be on that case? They can only decide cases and controversies of the parties, of the people who've brought a case before them. And I think that this is a much better and makes more sense legally for the court to just issue a restraining order only applying to the parties of the lawsuit. And so I just wanted to highlight this case for that reason. Okay. Case that I've been following. Another case that I've been following is the case that Yeah, 26 John Does, essentially anonymous individuals. Their identities have not been disclosed by the court, suing Elon Musk in his official capacity and DOGE. So I did a video on this. And again, all these videos I will link below, that if you want to watch those previous videos, I encourage you to do so to have a better understanding of the lawsuit. And so this case essentially was involving Elon Musk and DOGE dismantling USAID. And so they were employees, or, well, terminated employees or contractors from USAID bringing this lawsuit trying to stop the actions of Elon Musk and DOGE. But as I pointed out in that earlier video, that the court really, I mean, he granted a temporary injunction, but it was really on shaky ground, because he was trying to say these actions that Elon Musk is taking are like he should be a big O official or officer, and for that reason he needs to be confirmed by the Senate, which he hasn't been, and he can't take these actions because he hasn't been confirmed by the Senate. But even in his opinion, he admits that Marco Rubio, the Secretary of State, who now USAID falls under the Secretary of State, and the current administrator of USAID essentially ratified, or they're the ones who actually took the action. And he even cites the case law that if the Senate confirmed official, Marco Rubio, right, ratifies or actually is the one who carries out these issues, then there's no separation of powers issues. There's no constitutional issue, because, well, the person who was Senate confirmed actually took out and carried out the actions of the executive branch. And so even within his opinion, he almost contradicted himself, because he still granted the temporary restraining order. And so this was appealed. It was appealed to the DC Circuit. So let's take a look at that opinion. We just got an opinion a couple of days ago from the DC Circuit on this issue. Okay, so this is the opinion that we've gotten from the appellate court, and I guess it's in the Fourth Circuit. I thought it was in the DC Circuit, but it looks like it's in the Fourth Circuit. So they've considered the issue, and they have stayed that preliminary injunction pending the appeal. And so they provide their analysis and their reasons, and I will link this opinion below so you could read it for yourself. But essentially, it just goes through the facts of the case, explaining the background, and it talks about how, hey, Marco Rubio and the acting administrator have ratified these actions. And because of that, it's resolved any sort of constitutionality issue of these actions, because, right, agency discretion and the president's inherent authority to direct foreign policy, that's fine. They can do that. There's no issue. And later it talks about how essentially the parties to the lawsuit they've brought the lawsuit against the wrong people. They should have brought the lawsuit, right? They brought it against Elon Musk and DOGE. And I think the reason they did that is because they wanted to grab the headlines and put it in the news, and also bring up a bunch of tweets, or, well, whatever they're calling them these days, posts on X that Elon Musk did. And the court even talked about that this appellate court was at the lower court. That's kind of all the evidence that this lower court judge relied on to grant this preliminary injunction were posts on the internet and news stories. He didn't rely on actual evidence. And so they call that out, which I thought was interesting. But essentially their argument is, hey, you brought this lawsuit against the wrong people. You should have brought it against Marco Rubio and the acting administrator of USAID. And essentially they really signaled that they're going to lose this lawsuit if they proceed. Now, I don't know what's going to happen with this case, but if I were the attorneys for the plaintiffs, the appellants, I would probably dismiss it and then refile against the Marco Rubio and the USAID administrator. But maybe this case wasn't filed to win the lawsuit. Maybe it was just filed to do just kind of that, to drag Elon Musk into the news and make a bunch of hay about what's happening with DOGE and USAID. So I don't know. We'll see, but I'll follow this case. But that's what's currently the current decision in this case is that that temporary restraining order has been stayed pending appeal. So essentially, DOGE and Department of Homeland Security, or sorry, the Department of State can proceed with the dismantling of USAID. And so that's a good result for the Trump administration in that case. Okay, so there's a couple cases that I want to cover that I am not going to share the court documents because I'm going to cover them pretty briefly. So another case that I discussed in a previous video was the freezing of funds case. And so remember, there's a case with Judge McConnell that the government needed to disperse the funds that Congress was authorized. Essentially, Congress created the authorization for the spending of the funds, and the executive branch, under the Impound Control Act, they have to spend the money that Congress has allocated, or they have to go back to Congress and ask for a rescission. And so that freezing of the funds case, currently right now, it was appealed. So remember, there was a temporary injunction put in place. And so the judge was saying, you got to spend the money that Congress tells you to spend the money. And the government appealed that. And they were asking for a stay to, stop that injunction. And that appellate court denied the stay. So what that means is that Congress has allocated the funds and the executive branch needs to spend them, unless, right, there's fraud or other reasons. But that is, and like I said in that previous video, I think the law was followed in that case. Now, if you don't like it, if you don't like the result, what needs to happen is that Congress needs to go back and rescind those funds. And I know that at least Senator Rand Paul has put forth a bill to rescind those funds in line with the cuts that DOGE has made, but that hasn't passed yet. And what did Congress do when we had a funding issue and the continuing resolution was about to expire on 15 March? Well, they didn't pass a new funding bill that would make these cuts official and take it out of the budget. They just passed another continuing resolution, essentially just putting in law President Biden's budget. So it didn't take into account any of these cuts. It didn't reduce the spending, and it didn't make any of these cuts permanent. And so as I've said in previous videos, and I've said on multiple posts on Twitter, on X, these cuts that DOGE is doing are essentially meaningless because Congress has said this is the dollar amount of money you executive branch need to spend. And until Congress changes that dollar amount number, they're going to spend the money, whether it's on a contract for DEI that they've canceled, then they got to spend the money on something else, or they have to go back to Congress and say, this is why we're not going to spend the money. Remember, this law was passed during the Nixon administration back in the 1970s. And so that law requires that the Impound Control Act, that the executive branch spends the money that the legislative branch passes. So if we don't like that bill, Congress needs to dismiss it. Congress needs to get rid of that law. They need to pass another law that would repeal that law, the Impound Control Act from the 1970s. And so until they do so, kind of the DOGE cuts are somewhat meaningless because they still have to spend that money. All right. So, and then there's another case. I know this has really been in the news, well, at least on X, on social media. And I've kind of stayed away from it because, well, it really should be a non-story. But there's a bunch of signal chats between cabinet members discussing the bombing in Yemen. There was a lawsuit filed. It's currently just in, complaint stages, but essentially a lawsuit was filed asking the court to essentially enjoin, right, another preliminary injunction to stop any government officials from destroying any of those chats, to ensure that those chats are preserved as required by the Federal Records Act. And this is kind of a no-brainer. I think the plaintiffs absolutely should win. These government officials, even if they're having these communications via Signal, which is widely used in the intelligence community. And I can tell you, friends of mine who deployed recently to the Middle East have said that, yeah, absolutely. They've used Signal chats. That was pretty standard. And so no issue with that. But the bigger issue is that if it's official communication, it does need to be preserved. And so I have advised different people in my roles when I worked for the DoD to say, hey, if you're having this offline, off channel, off government official email or government official communication channels, those need to be preserved because you could potentially get a FOIA request for those conversations. And so anything official needs to be happening on official government channels so we can preserve it in case it comes up later, maybe in a lawsuit or maybe a FOIA request that we have to have those documents later. And so I think the government does need to preserve these records. And so kind of no issue on that. All right. And then another case that I wanted to discuss is the probationary employees. And so currently there is a stay. So I'm just bottom line up front. But previously, there was executive orders that came out and said Trump wanted to reduce the size of the government. And so because of those executive orders, OPM, which again, Office of Personnel Management, essentially they do HR for the government. They don't actually make any decisions. They don't make personnel decisions. They just give advice to the different government agencies on personnel issues. And so they issued guidance to government agencies that essentially, hey, probationary period is, you should view it as an extension of the interview process. And so if a probationary employee, one usually with less than 1 year or 2 years, depending on the agency, of service after they have been hired, if they're in that probationary time period, they have less due process rights. So they have less of an ability to sue if they were terminated. And so they said, hey, you should view this as extension of the interview process, which is nothing new. That was current. They're just reiterating previous OPM guidance and regulations, and essentially, in a way, encouraging government agencies to terminate probationary employees because, well, it's a lot harder for them to bring a lawsuit. And so several, if most of the major government agencies did bring those termination actions, and they based them on like performance. But for a lot of the employees, at least a lot of the pleadings that I have read, didn't tie that to that specific employee, just kind of had blanket language provided by OPM that was used in like emails. And sometimes in some of these cases, there's a case out of the VA that was in the MSPB, the Merit System Protection Board, which is a government agency that handles these kind of personnel actions, adverse personnel actions. In that case, it was a VA employee who her direct supervisor was not ever, they were never consulted, and this employee was terminated, and the supervisor provided an affidavit for that terminated employee saying, hey, I would have never terminated this employee. Her performance is outstanding. So she didn't have any performance issues, even though the email terminating her said that she was being terminated for performance issues. And so there is a case that was filed in the Ninth Circuit, I believe in the Northern District of California. Let me find it and pull it up. Okay. And so this case was filed in the Ninth Circuit in a district court. And then that case was filed by mostly labor unions. And then later, other groups joined that lawsuit. And then the district court judge, sua sponte, which means on his own, issued a preliminary injunction saying that the government couldn't continue to take any action against probationary employees, and then actually ordered the government to reinstate, I believe, about 18,000 probationary employees who had been terminated. And that was totally on his own, on no motion from the plaintiffs in that case. So that preliminary injunction and the ordering of the reinstatement of probationary employees was appealed to the Ninth Circuit. And they asked for a stay of that order, and the Ninth Circuit denied that stay. So now it's been appealed to the U.S. Supreme Court. So this case is currently up on appeal at the U.S. Supreme Court, asking for the U.S. Supreme Court to intervene and to stay the lower court rulings. And so let's take a look at this. This is a filing from the DOJ, from the Solicitor General's office, to this U.S. Supreme Court. So it's argument on behalf of the government. So let's take a look at it because it has some pretty interesting information in it. So let me find some issues. So there's an acting Solicitor General right now. We don't have the current Solicitor General. And so let's look at it. I have some highlighted. These are all the plaintiffs and respondents. So these are the defendants, essentially all the U.S. government agencies. And so it involves like all the major agencies. So we got like Health and Human Services, DOD, VA, NASA, National Park Service, Department of Agriculture. I'm just reading Department of Homeland Security, HUD, all the major agencies, Treasury, etc., OMB. And then respondents. So we got the unions, and then we have these different non-government organizations, NGOs, climate resilient communities. I've never heard of any of these. Coalition to Protect America's National Parks, Common Defense, Civic Engagement, all these. I mean, I would kind of guess maybe lobbying groups. So they've joined this lawsuit. These are the cases below. And so let's see what, over 16,000 probationary employees have currently been terminated. Like I said, this trial court just didn't even, the lawsuit doesn't involve the employees. It involved, it was filed by the unions, and I pointed out in a previous video on a different case, really likely do not have standing. So they don't have the ability to bring the case. They're essentially the wrong party to the case. They're really not the one aggrieved or the one harmed. And so the union shouldn't be the one to bring that case. And they make that argument. And so then they also argue that, hey, these other plaintiffs that were brought, they don't have it's shaky ground for them to have standing as well. And so it just provides background facts. But something that I wanted to point out, so it talks about, so far there's been this nationwide preliminary injunction ordering 6 federal agencies to immediately reinstate to full duty status more than 16,000 terminated probationary employees. And like I said, this was not, the parties didn't even ask for this. The judge just on his own decided to order this. And so they say it's remarkable given that the respondents didn't even move for it. He just issued this preliminary injunction from the bench during the hearing and then later followed a written opinion. And later the court, or this pleading points out that the court said that they couldn't be just rehired and then put on administrative leave. They have to be put back in their jobs. And so this is good language. It says this court should not allow a single district court to erase Congress's handiwork and seize control over reviewing federal personnel decisions, much less to do so by vastly exceeding the limits on the scope of the equitable authority and ordering reinstatement en masse. So essentially arguing, hey, this single district court judge doesn't get to decide who works and who doesn't work for the federal government. These personnel decisions should be made by the executive branch. The Congress has given control over the executive branch for their federal employees, and this district court judge does not have the authority. He's totally exceeding his authority to order these reinstatements, which I agree with that. And we'll see how the Supreme Court rules on this. I mean, the Supreme Court could just punt it and say, like, hey, we're not going to hear this stay. We're not going to hear this case, and then send it back down to the Ninth Circuit. We'll see what they do. Or they could issue a stay pending appeal. We'll see. And then this other interesting language. So it says this preliminary injunction, and I'm quoting from these pleadings, also contribute to an untenable trend. In the 2 months since Inauguration Day, district courts have issued more than 40 injunctions or TROs against the executive branch, whereas district courts issued 14 universal, meaning, applies everywhere, not just to the plaintiffs, but to all. So nationwide injunctions against, I'm reading again, against the federal government through the first 3 years of the President Biden's term. So compare that. So they're saying there were 40 nationwide injunctions against President Biden throughout his whole 4 years as president. But so far in just 2 months, there's been 40, more than 40 against President Trump 2.0. And then there's been 15 universal injunctions or temporary restraining orders against the current administration in February 2025 alone. So just in 1 month's time, more than the entire Biden administration. They said this situation is unsustainable, emboldened by the lack of prompt appellate review, i.e. by you, Supreme Court, foot stomp, often occasioned by the use of the TRO mechanism. District courts have now issued dozens of orders without sufficient regard for limits on their own jurisdiction or to defects in the plaintiff's representation about the law or the underlying facts. Remember the case we just reviewed, right? That the district court issued the stay again, or the preliminary injunction against Elon Musk and DOGE, and all he relied on was news reports and posts that Elon Musk made on X, that the higher court said he's kind of got nothing, didn't rely on actual evidence, just relied on these. So this argument is a really, really good argument. Okay, so I'm going to continue reading. Those orders have sown chaos as the executive branch scrambles to meet immediate compliance deadlines by sending huge sums of government money out the door. That's the freezing of the funds case. Reinstating thousands of lawfully terminated workers. That's this case. Undoing steps to restructure executive branch agencies, and more. The lower court should not be allowed to transform themselves into an all-purpose overseers of the executive branch, hiring, firing, contracting, and policymaking. So this case, maybe we'll see some action by the Supreme Court, but I think it's a well-timed, well-argued request to the Supreme Court to say, hey, you need to step in. You need to rein in these district court judges. And it's not stated in these arguments, but I would argue from this outsider political point of view, hey, Supreme Court, you need to get a handle on these district courts because the American public is losing faith and confidence in the role of the judiciary. They should be this non-biased, non-political arbiter of, we're just going to interpret and enforce the law and, ensure that parties are following the law. And then when they're not, we're going to find in favor of, the opposite party. And right now there's the American confidence in the role of the judiciary has really, really taken a nosedive. And so the Supreme Court does, in my opinion, need to step in to right that, because legitimacy of the courts is, I believe, very important. I think it's important for the rule of law. I think it's important for an orderly society, a a society where we run to the courts to decide our disagreements versus having violence in the streets. Okay, so I'm going to continue going through this brief to the Supreme Court, just discussing OPMs, talking about the rules for probationary periods, about how there are mechanisms for those employees to bring any sorts of suits themselves, either through the MSPB. Now, probationary employees definitely have less rights to bring a case at MSPB. I think that's why that they were targeted. So federal employees in their probationary period generally don't have a right to appeal to the MSPB, but there's specific issues like if you were terminated for your political affiliations, I think marital status, I think those are there's a few things that they can bring a case. And so they're essentially saying that like, hey, that's where these grievances should be held, not at the district court by these plaintiffs, i.e. the unions and these like other, we don't even know, like these other organizations who are claiming there's some sort of attenuated like harm, right? Because they can't like go to a national park and there was a bathroom that was closed. Like, I'm not joking that came up in the argument. Okay, and so then it discusses, as I explained, that there was emails sent out to the different agencies saying you can use this attached template, and make sure that you track these employees and whether you're going to terminate them or keep them. And a lot of the agencies were using this template, and so that gave the plaintiffs in this case argument to say OPM was directing these terminations. And it wasn't the actual agency who was making these decisions. It was OPM. The government obviously is arguing in opposite, saying, no, it really was the government agencies, not OPM making these decisions. All right, so numerous agencies started terminating employees. And so it just goes through like the facts. The unions, they filed this complaint, and then these additional organizations. So 5 additional organizations. And a big part of their argument is that these groups, these plaintiffs, do not have standing to bring this lawsuit. But this explains the court. So the court said that the unions can't bring this lawsuit, that the court lacks jurisdiction because the union should go to the FLRA, the Federal Labor Relations Authority. That's normally unions when they bring a lawsuit against the government for some sort of, maybe collective bargaining issue or some other grievance. That's where they go, is the Federal Labor Relations Authority. That's essentially a quasi-judicial body created by the Federal Labor Relations Act that created this forum for disputes between the private or public sector labor unions and the executive branch agencies, and then or that it should be an MSPB. So the court is saying that like, hey, it recognizes that these cases probably should be held elsewhere and the court doesn't have jurisdiction to hear it. And so, but then the court said, based on these like end user organization, these other like 5 organizations, they think that like, we probably have the ability to hear this case. And so they said, well, the district court judge, I'm going to go ahead and rule on this. And then, like I said, issue this preliminary injunction, this temporary restraining order that didn't even, they weren't even asked for. So here, this is where I talked about respondents had never filed a motion for that relief and defendants never had an opportunity to respond for the motion. He just did it on his own. So he ordered these different departments to immediately reinstate any and all probationary employees terminated between February 13th and February 14th, 2025. Cease any termination of probationary employees at the direction of OPM, cease using the template termination notice provided by OPM, and submit within 7 days a list of all probationary employees who've been terminated, quote, with an explanation as to each of what has been done with to comply with the court's order. So pretty sweeping order, and in my opinion, unprecedented. All right. And it says that it's reiterating this lower court, this district court judge says it's only based on these organizational respondents. It wasn't providing this relief, this temporary restraining order based on the unions. And so I think it's like also a difficult thing to row. I don't think these organizations have standing either. And then also specified, and I said this earlier, that placing them on administrative leave is in compliance with this order. This district court judge says they have to go back to their job. Like they have to be reinstated to full employment. All right. And then the government's making this argument, hey, that this is totally extraordinary and exceeds the district court's authority. And so that they think that the government is going to win later on the merits of the case. And so the Supreme Court needs to step in and stay this order, goes through the law. I'm not going to go through this all. Again, I will link this opinion, or this is an opinion. This is a brief to the U.S. Supreme Court by the government. So I will link that below if you want to read that. All right, I'm going to see if I have some other highlighted portions. I think, going through. Okay, so this is what they're asking for. They want the Supreme Court to step in and stay this district court's preliminary injunction. And they want to, have the Supreme Court step in and tell this district court, and I think they want the Supreme Court to step in and essentially send a message to all district courts that, hey, you need to stop with these nationwide injunctions. You need to actually have hearings on the merits, don't have these preliminary injunctions. And so we'll see. Or maybe the Supreme Court will step in and say, hey, these nationwide injunctions need to go away. There's previous Supreme Court precedent that I believe it's Hawaii versus Trump, that discusses that, hey, these nationwide injunctions it's really exceeding the district court's authority because they can't issue an order to people who aren't party to the lawsuit. And so I think potentially if the Supreme Court steps in, we'll see more temporary restraining orders that are narrowly tailored, like the one in the transgender case where it only applied to the two plaintiffs in the lawsuit. That's if plaintiffs want relief, they need to join the lawsuit. So I think that potentially we'll see that in the future, but who knows? Who knows what will happen? I don't know what the Supreme Court is going to do or if they're going to step in. Okay, and so that is the end of my week in review for the last week of March in 2025. So a lot has happened. There's even more. So I'm going to have some other videos discussing some more action that has been taken, particularly in regards to the DOD. So just recently, Pete Hegseth signed a memo kind of reshaping the DOD workforce. DRP is back. Deferred resignation program is back for the DOD. And I think that will be implemented in the next couple of weeks. But that was pursuant to this memo that was just signed by Pete Hegseth, that essentially reshaping of the civilian workforce is coming to the DOD. Voluntary early retirement is coming, and I believe followed after those two voluntary programs, the deferred resignation program and the voluntary early retirement. I believe after those are coming, then the involuntary actions are coming. So I think RIFs are coming, and potentially other sorts of termination actions are coming. And so I'm going to cover that in a later video. So thank you for joining me. Please hit the like, share this video out there, subscribe to the channel. Again, I'm a new channel. Please help me grow. So share this video with anyone you think would get something out of this content. And thanks for joining me. I'll see you in the next video.